matter of the Queen on the application of Richard and the Environment Agency and others.
Yes, Mr. Mould. Just before you get started, I think there have been a few problems with the live stream this morning, but I'm told that it's working properly now. We may have to pause if it goes wrong, but at the moment I think it's working.
Thank you.
Thank you.
My Lord, this is the Environment Agency's appeal from the order of Mr Justice Fordham. His judgment appears in the core bundle at 12. In this appeal, I appear with Miss Jacqueline Lean for the agency. Mr Ian Wise, Queen's Counsel, and Mr Will Perry appear for the first respondent, that is Matthew Richards. The second respondent is represented by Mr David Hart, Queen's Counsel, and Mr Thomas Beament. I should say that Mr Wise was also assisted, I think, in writing by Miss Catherine Dobson, but she's not appearing in court today.
Yes.
Mr Wise not only responds to the agency's appeal, but also has a cross appeal,
Yes.
for which he has permission to proceed, just as indeed as the agency has permission to proceed with its appeal.
But only on one ground, though.
I'm so sorry.
Only on
one ground, that is to say whether the judge was, I think this is a correct encapsulation, whether the judge was wrong in concluding that there was no, or declining to find that there was a present breach
Yes.
of the relevant rights.
Yes.
Articles 2 and 8 in the Convention.
Yeah. Have you, between you, decided upon a sequence of
We have
submissions? Yes. Which is
this, if it's convenient to you. I shall open, focusing predominantly on the appeal. Mr Wise will then respond to the appeal and open his cross appeal.
Yes.
Mr Hart will then respond, present his case. I will then respond to Mr Wise's cross appeal.
Yes.
And reply.
Yes.
And Mr Wise will conclude the argument by replying to my submissions on the cross appeal.
Yes. That seems to me, subject to my colleagues' view on the matter, to be a logical and compact sequence. We agree.
Thank you. It offers plentiful opportunities for the unscrupulous advocate to try and broaden the scope of his submissions, but none of us is unscrupulous.
Well, that observation is entirely correct, but entirely extraneous to these proceedings.
Exactly so.
Well, that's fine. And have you also discussed a broad timetable?
We have. We think that we have a fair chance of concluding each council's main submissions today.
Yes.
With Mr Wise's, with my response and reply tomorrow, and Mr Wise's reply tomorrow.
So it looks like a day and a half.
A day and a half is probably a fair assessment. Yeah.
Yes. Well, that's fine. Thank you.
Can I just check as usual, the documentation? The court should have a core bundle and a supplementary bundle. There is a bundle of authorities. There are replacement skeletons, which I think arrived separately with bundle references. And I think I'm right in saying there are 4. There's my appeal skeleton with Miss Lean.
Yes.
There's our response to the cross appeal skeleton. Then there's Mr Wise's skeleton, which I think deals with both. And I think Mr Hart also deals with both.
I've got 2 supplementary bundles, a main supplementary bundle and a respondent's supplementary bundle.
I suspect, I think the intention is that the supplementary bundle, which runs to some 563 pages, is a bundle that aggregates the supplementary documents in the appeal and also the first respondent supplementary documents in the cross appeal. That I think is the explanation for it being a relatively lengthy document, so I hope that you can discard the second of those.
Right. It runs to 562 pages and 35 tabs.
That's it? Yeah.
Yes?
There is one addition for which I'm responsible to the authorities bundle. I have asked that we add in a clip of section 628 of the Human Rights Act, which perhaps was an obvious omission from the authorities bundle. Can I suggest we put that in just behind the index? That's convenient to you.
Yes, we'll do that. Yes.
My Lord, the agency's grievance in this appeal is essentially with the judge's decision to intervene and to grant the declaratory relief, which is set out at the order of the court. Well, it's set out in paragraph 64 of the judgment, but the perfected version is at page 81 in the core bundle, behind tab 11. And I think I'm right in saying that the change that took place between the declaration that the judge proposed in paragraph 64 of the judgment and that which he the declaratory relief that he made in his order at page 81 was the addition of the word daily in the third full line from the bottom on page 82. And he explained why he was inclined to make that change in paragraph 66 of his judgment on page 134.
Yes, and it's common ground, is it, that the date of January 2022 means the 1st of January 2022?
The 1st of January, yes. Yes.
That's common ground.
That's consistent with the judge's reading of the Public Health England second recommendation.
So we are to understand the order in that way?
Yes, yes. In our skeleton argument at paragraph 2, we have summarised the circumstances in which the judge granted relief in the form of that declaration. It was in response to, it was granted in circumstances where, in response to what, I quote the judge, a steadfast submission on behalf of Mr Wise, the judge emphasised that he declined to find that the appellant was presently in breach of its legal obligations, which he said in the body of his judgment at paragraph 64 and reiterated in his consequential conclusions at paragraph 68. I'll give you the references. Where mandatory relief was no longer pursued, it had been pursued in the claim form that was no longer pursued, and that was recorded in paragraph 3 of the judgment. And where an advisory declaration had not been sought by Mr Wise on behalf of the first respondent, he decided he was justified in granting declaratory relief for the reasons he gave in paragraphs 63 and 64 of the judgment, which in a sense is where the agency's complaint is alights insofar as the judge's reasoning is concerned. He said that it should be made to provide clarity as to what the Environment Agency's obligations are and what the EA must, in law, do. And your Lordship would have seen from the written submissions that there's a certain significance in his emphasis on what the EA must, in law, do. A declaration, if it's anything, is a declaration as to legal, as to the law and as to legal rights and obligations. And so one has to assume that if in due course the first respondent or others within the community around the landfill are of the view that the terms of the declaration at pages 81 and 82 have not been fulfilled, that they will bring a claim simply saying that there is a breach of the law as stated in the declaration. And that is a source of concern for reasons that...
Well, the only people who could bring a claim would be the mother, the child, the landfills, or the authority. You're the only people who are bound by the declaration. Other people may bring a fresh action and rely on it. But they...
Well, my lord, as I understand it, the declaration having been made, it's a declaration which is good for the world, to the world.
The declaration is to what the judge thinks is the content of Article 2 and Article 8.
Yes.
And other people may say there's been a breach of Article 2 and Article 8, but the declaration only binds the parties to...
It only binds the parties, but it is at the very least a powerful indicator that if the matter were raised again in litigation by, shall we say, some other person who may not experience the acknowledged vulnerabilities of Matthew with his respiratory illness, but who nevertheless says that as a result of a failure in this scenario to fulfil the precise requirements of the declaration, their health also is being put at risk. The Article 2 or the Article 8, it's more likely the Article 8 trigger has been pulled, and therefore they have the basis for a claim under the Human Rights Act. That at least I would submit is not an unreasonable scenario to look forward to in the light of the way in which the judge has intervened in this case. But I take your lordship's point as to the precise force of the declaration. My lord, might we just look at paragraph 3 of the judgment, page 85 of the core bundle, where the judge summarised with a more detailed exposition in later paragraphs the case that was advanced on behalf of Matthew Richards as the claimant. And one sees that the basis for the claim, about halfway down the paragraph, was an ongoing failure by the agency to comply with its Human Rights Act and common law obligations. The court should make declarations that the EA's failure to take measures necessary to protect Matthew is a violation of his Article 2 and his Article 8 rights. So the focus was on the availability of measures beyond those that the agency, on the evidence, had and was continuing to take. In fact, the statement of facts and grounds focused on one particular power available to the agency, which is to serve an enforcement notice under the 2016 permitting regulations. But there was also a suggestion that the agency ought to have and had not invoked its powers to suspend operation of the landfill and or its powers to revoke the operator's environmental permit. But that was the focus of the complaint. And then the court is not, as was clarified in Mr. Wise's oral submissions, being asked to make a mandatory order requiring any particular operational step or steps. However, the court must not proceed on the basis that there's some safe level of hydrogen sulphide emissions which the EA should be requiring the IP to achieve. Now that's important because that was a key point of debate and dispute in the hearing before the judge below. And your lordships will have seen from the judgment many paragraphs of which record the competing expert views of Dr. Sinha on behalf of Matthew Richards and the professor on behalf of the operator as to Professor Berry as to the question whether there were in fact safe levels of hydrogen sulphide for health purposes in the vicinity of a landfill operation or an industrial operation that generates that gas, and if so, as to where those safe levels should land. Dr. Sinha's position was that there were no safe levels beyond natural ambient gas in the atmosphere. Professor Berry's evidence was, speaking as a toxicologist, was that the safe levels were considerably above those that were spoken to in some of the published literature. The judge said that both experts had expressed their views conscientiously and expressed honestly held opinions, but he found deploying a precautionary approach to that question, which is an approach that will resonate with members of this court who have experience of litigation in this field. The judge found solace, if you will, or found a bright line, if you will, in the evidence given on behalf of Public Health England, which is now the United Kingdom Health Security Agency, which is the responsible statutory body in relation to the maintenance of public health. And that body had identified certain levels, certain guideline levels in a series of reports which it had been asked to produce and to publish in relation to the problem with landfill gas emissions that had arisen at this landfill site during the early part of 2021 and persisted at the date of the hearing before the judge. And that evidence was, there was evidence given by Mr. Coetzee, Dr. Coetzee, I think, on behalf of Public Health England, covered in the supplementary bundle, and he produced those reports, which in a sense were cumulative, and the one which most recently published at the time of the hearing before the judge was NC4, which you have in the bundle, which the judge addressed in considerable detail, paragraph 32 to 34 of his judgment.
Just briefly on that, the judge understood Public Health England to have gone for the 3 risk assessment guidelines set out in Table 2 of that June one. From the judgment, it's not entirely clear, but is there evidence about what your client was saying, whether your client agreed that certainly unless things changed, they would use those 3 measures as well, or?
There wasn't evidence from one of the agency's witnesses that said in terms, we shall design, if you will, to seek to achieve the levels set out in Table 2. The simple fact was that NC4 had been published on the 5th of August, and the agency's evidence had been produced on the following day. So, there were 2 points of reference. Firstly, the detailed grounds of defence. I'll show you that in a moment, which set out the agency's position in relation to the guidance from Public Health England. And secondly, what I said to the judge as he records in paragraph 59 of the judgment. Can I take you to each of those in turn? Yeah. Firstly, the detailed grounds of defence, which you have in the core bundle at tab 14. And if you can turn to firstly page 141. At the top of the page, you'll see this was said. the Environment Agency has worked and continues to work closely with Public Health England regarding potential impacts of landfill gases, and has done so specifically with respect to Walleys Quarry since the early part of this year. Public Health England has been provided with Dr. Sinner's report and addendum. Public Health England has confirmed that the information provided in those reports would not lead it to change its risk assessment approach, including health-based guidance values used to assess the potential risk for health. So that was one specific issue that the agency asked Public Health England to consider, and Dr. Coetzee's evidence addressed that on behalf of the agency. The second, more general point is at pages 162 and 163, paragraphs 72 and 73 of the agency's defence. 72, I'll read those paragraphs out if I may. The agency has not, the Environment Agency has not failed to inform itself as to the impact of hydrogen sulphide on children. As set out above, the Environment Agency has proceeded on the basis of guidance and advice from Public Health England as to the potential health impacts of the observed hydrogen sulphide emissions. Public Health England has confirmed that the various health levels are set at a level which is protective of the whole population, including susceptible groups. It is submitted that it's appropriate for the Environment Agency to have relied on the advice from Public Health England as the responsible national body for public health and for protection from public health hazards. The agency has not acted in breach of the obligations in relying on the advice of Public Health England in preference to that of Dr. Sinner. Finally, there's a denial about of a failure to take the necessary urgent actions to protect the claimant from hydrogen sulphide emissions from this site. Detailed above, since January 2021, the Environment Agency has both identified and required the interested parties to take effective action to address the increase in hydrogen sulphide emissions from the site. Neither revocation of the permit nor suspension of the permit would not be effective for that purpose. In summary, acting as the expert statutory agency responsible for regulating the management of gas generated by landfill operations at the site, the Environment Agency has taken and continues to take the necessary effective action to ensure that hydrogen sulphide gas emissions at the site are controlled and managed in accordance with the guidance and advice of Public Health England for the protection of human health. The court should be slow to intervene in such a case. There is no basis for intervention in the circumstances of the present claim. So the agency's stated position before the court was that it was working in concert with Public Health England, and it was being guided by Public Health England as the responsible specialist national agency as to what it should do in order to achieve an acceptable level of air quality, particularly in relation to the incidence of hydrogen sulphide in the areas surrounding the landfill site, and the measures that it should take in order to achieve that effectively. I emphasize effectively. And that it would continue to do so. So the judge was quite right in what he says in paragraphs, I think, 62 and 63. There wasn't a specific evidential commitment on the part of the agency to designing measures or reviewing those measures that were already designed and in place with a view to achieving the, quote, strong recommendations of Public Health England, which were the culmination of NC4. But there was nothing to suggest that the agency had any other purpose in mind. And the agency's stated position, which I reiterated one might even say repeatedly in oral argument, was that was the agency's position was that it would continue to be guided by Public Health England. The judge, in a nutshell, the judge didn't think that was enough, and he felt that in the circumstances the court could and should make the declaration in order to effectively tie the agency in to that which had been said in detailed grounds of defence as a matter of general approach, and to the specific fulfilment of that approach insofar as NC4 is concerned.
One thing that was not clear, and just to help you on that, you said reviewing and designing, and the declaration is all about designing, without knowing anything about the details of this. Presumably, after you got the June report on the 5th of August, and where it raised for the first time the recommendation in relation to levels being below whatever it is, one part
The long-term,
the long-term one.
Yes.
Presumably, you could have considered whether or not the measures in place would achieve that, or you could have said, no, they won't achieve that, and we want more. I mean, was there any distinction drawn between reviewing whether the existing measures would achieve it, or was it accepted that there'd have to be further measures?
That point hadn't been resolved by the time of the hearing. And certainly the question whether there was the agency's willingness to review the measures that it had put in place was something that was stated clearly in the evidence. I can show you that now if it's helpful. We need to go to the supplementary bundle. I want to bring you back to paragraph 59 of the judgment in a moment, but I'm happy to deal with this now. If we could go to the witness statement of Sarah Dennis, which is at tab 12. Beginning at page 243, under the heading Future Improvement Measures, which Sarah Dennis, who was essentially the responsible case officer with the agency for the regulation of this site, she set out those measures that were in prospect at the time she wrote her evidence, paragraphs 118 through to 127, and she produced the timetable for the programme for those future measures, which you have behind tab 16 at page 319.
This is all to do with their plan, the interested parties' plan. In a sense, is that hard to say to Ms Dennis she should have said on the 6th of August what her response is to something that came on the 5th of August?
Yes.
But it's just whether, it's a minor point, but whether the declaration is on the assumption that you've got to go off and design and apply measures. So designing means you've got to create them. And I'm just wondering whether there is a possibility that what is there and what will come from the interested parties plan may do it, or whether it was accepted that you'd have to do something over and above what was already in place.
There wasn't, at the time of the hearing, I had not been told that a firm conclusion had been reached about whether something more would now need to be done.
Your client's position was that if there was something more that objectively needed to be done, it would be done.
Yes.
And presumably it was also your client's position that there was no evidence to suggest that that degree of, if you like, adaptability of approach, there's no evidence that that adaptability had been shown wanting or ineffective.
No, exactly so. If the concern was whether the agency was willing, if necessary, to review and, upon review, to adjust, to impose further measures, whatever it may be, there was no reason for the court to draw an adverse conclusion. Absolutely none. and your lordships may think that that resonates in the terms of Section 7 and Section 8 of the Human Rights Act, where insofar as future actions incompatible with the convention are concerned, the language of the statute is proposes to act in contravention. There is no suggestion, no evidence at all, in my respectful submission, to support the contention that the agency proposed to act in a way that was in contravention of the claimant's Article 2 and Article 8 rights, if one follows the judge's analysis of what the positive duty consisted of. The judge's concern was that the agency hadn't produced a document entitled Plan, which identified the recommendations of the Public Health England as the end point, as the goal.
But in a nutshell, you were prepared to check existing measures, you were prepared to review the IP's plan, and you were prepared to take any further necessary measures to achieve the aims set out in Public Health England.
Yes, and paragraph 128 of the of Miss Dennis's statement on page 246 indicated the agency's intention to continue to review its position.
Sorry, paragraph?
128.
Yeah.
The agency will continue to review its position and the response from the interested party in accordance with guidance, relevant legislation and the regulator's code. Currently, the interested party is responding to our regulatory action requiring it to bring the SAP back into compliance with the permit. At the very last paragraph, the conclusion on page 248, the last sentence indicated the agency's position was to continue to require the interested party to make improvements to reduce emissions in the shortest timescales possible. Now, those are expressed in general terms, I accept that, but they are nevertheless clear in their intent. They are reflected in the evidence of Mr. Browell, which you have at tab 18. Page 322. Mr. Browell, his evidence was of some significance here, having regard to the established principles of the court as to the weight that the court will afford to the technical judgment and expertise of the agency. He was the senior advisor, landfill gas in the Environment Agency. He'd been employed by the agency and its predecessor, the Waste Regulation Authority, since 1991, with over 30 years' experience in regulating landfill sites and dealing with landfill gas. Mr. Browell, at page 341, paragraph 62, all the way through to 72, told the court what the orthodox and effective means of controlling landfill gas exceedances was in relation to operational landfill sites. He did so by reference to the agency's published guidance, technical guidance on that question, from which the court had extracts at beginning at pages 35, behind tab 19, pages 348 to 369. I don't think I need to take you to that in detail, but it was guidance published precisely to guide operators as to how they should manage and control landfill gas and landfill gas exceedances. So Mr. Browell says to the court, this is how one does this. This is the tried and trusted means of doing it, addressing the problem that has arisen in 2021 on this side. And then at paragraphs 73 through to 78, he says, as senior advisor within the landfill and deposit for recovery team in the agency's Environmental Business Directorate, one of my roles is to provide appropriate technical support to colleagues in the area delivery teams. He's been working with colleagues in West Midlands to provide advice in resolving the current issues of this site. And essentially, in the following paragraphs, he expresses his endorsement of the strategy for bringing gas emissions, in particular H2S emissions, down to acceptable levels at this site, which has been imposed, if you will, on the operator, and which Miss Dennis speaks to in more detail. And at 78, he says, the process of improving the landfill gas system is an iterative process, and the agency will continue will ensure that further improvements are made as necessary. We will continue to monitor the impacts of the site to demonstrate that improvements are effective. Now, so what you have is the Environment Agency, as the regulator, having a serious problem to resolve. There's no doubt at all that the problem that arose at this site in early 21 is a very serious problem. And no part of my case today, nor indeed was it on before the judge, to seek to quarrel with the impact that Matthew, but also the local community had endured in that respect. The agency's task was to find was in the exercise of its powers as regulator to identify the source of that problem and to put in place through its regulatory powers, both under the terms of the permit and under the regulations, the permitting regulations themselves, 2016, to identify and to put in place steps, measures that the operator was required to take progressively, incrementally if necessary, in order to bring the problem under control and to bring gas emissions, particularly H2S, down to levels that were acceptable. It invoked the advice, the help of Public Health England in order to identify what on the basis of published guidance and Public Health England's own specialist technical advice, what those levels were, what the safe levels were that it should be seeking to achieve. Public Health England gave that advice. They gave evidence on behalf of the agency in response to the claim. And the agency put in place a monitoring regime, which Mr Lowe speaks to in his evidence behind tab 21, page 379. The monitoring regime, essentially, the landfill was surrounded by monitoring stations at all points of the compass in order to have a real-time, build up a series of a real-time evidence base as to the performance of the site and the performance of the measures progressively over time. And thus provide the best evidence, if you will, from an objective standpoint, to test whether the measures were working, whether the trend was downward and in a timely and appropriate fashion, and if not, to judge whether, on review, further needed to be done. And Public Health England provided their own clear and objective assistance in that respect by identifying the measures that would need to be, against which the results of that air quality monitoring work needed to be appraised. And we know that that on the basis of the measurement that was appropriate in order to assess progress in remediation of the problem during 2021, that was the intermediate level. We know that the environment, that the Public Health England's analysis was that the site was performing within the appropriate guideline levels for the purposes of protection of public health on that basis. We can see that if we just turn to NC4. To Dr. Kurtz's evidence. So behind tab 22. Page 394, paragraph 11. Health-based guidance values are applicable over the time period specified in Table 2 of the risk assessment. I'll come to that in a minute. This means that the World Health Organization AQG value of 150 micrograms per cubic metre, 107 parts per billion, is considered suitable for consideration of short periods of acute exposure because it protects against eye irritation. The ATSDR intermediate value of 30 micrograms per cubic metre, 20 parts per billion, is the suitable value to assess the exposure to hydrogen sulphide throughout 2021, and the US EPA reference concentration RFC of 2 micrograms per cubic metre, 1 part per billion, has been selected by PHE for use to assess long-term exposure to hydrogen sulphide. Then at 16 in the page, to assess the risk from the increased concentrations in 2021, the concentrations have been compared to the US Department of Health and Human Services Agency for Toxic Substances and Disease Registry, ATSDR, intermediate minimal risk level for exposure between 14 and 364 days. And the MRL has not been exceeded. As a result, currently any risk to long-term physical health is likely to be small. However, Public Health England would stress they cannot completely exclude a risk to health from pollutants to the area, especially if exposure continues at these levels. Hydrogen sulphide data up to the end of June 2021 shows continuing exposure to the population around the site above levels acceptable for long-term lifetime exposure. That's the 1 part per billion that we've seen. But it's important to see that so far as the intermediate value, which was the suitable value, is concerned, for the purposes of, if you like, to chart the progress during 2021 of the measures, the effectiveness of the measures the agency had in place, and would continue to pursue and to review throughout the remainder of the year in order to bring matters back into control. The Public Health England's position was that there was no exceedance of that value.
Is that really correct, though? Because there would be no exceedance in the sense that there'd be no problems if it was only for up to 364 days with those levels. But if nothing was done to improve the situation, and if they continued beyond 364 days, there would be a problem.
Yes.
Because it really is cumulative, and that's why Mr Justice Fordham chose the 1st of January.
Hence Public Health England's strong recommendation in relation in NC4. But the point, but if the question is, what does the health risk assessment report tell us about the current position? The answer is it tells us that applying the most suitable measure, the current position, albeit it's one that isn't acceptable if it was to be prolonged into the longer term, it is an acceptable position so far as health risk is concerned.
It's acceptable so long as you're doing something or
Yes.
getting ready for the next year.
Yes, but the
And he didn't declare that you must do something this year. He declared that you must do something next year. That's
he did.
the thing you're complaining about.
Our question there was whether, in the light of that, and in the light of, the judge alighted on that and accepted this is for the court's note. This is paragraph 32, subparagraph 6 of the judgment. It's at page 104. You see that he records my submission. He says, this is about 5 lines in order to understand this is the 14 to 364 days intermediate level. In order to understand this, I raised with all counsel this question: what was it that made 2021 year 1 up to day 364 so far as hydrogen sulphide emissions from the quarry are concerned? Mr Mould QC, who appeared, Mr Laing, supplied what in my judgment was a convincing answer. he pointed to PHE's assessment that 2017-19 emissions were below US EPA reference concentration. Judge gives the reference for that. He submitted in essence that having found compliance with this guideline in years prior to 2021, PHE was justifiably treating the increased emissions experienced so far in 2021 as being a new problem to which the intermediate value was applicable. I accept that explanation of PHE's reasoned analysis. That's my submission. Coherent and logical, joins the dot, etc., etc. Then in the final sentence, the intermediate value being days 15 to 364 would not be applicable from January 2022. Mr. Mould accepted this was the logic of his explanation. I agree, and that's your lordship's point. And I accept, and that then took us to, but that then took us on to what I said in paragraph and what he characterised as my step 2, paragraph 59, at page 128.
Just one minor point, and I really don't think much says in it. Although you accepted 2021, it's not a calendar year, just you why it's a calendar year. The first monitoring station started in March, and there were a couple more in April. So if you're looking at having to do this by the 1st of January, and they needed another 2 or 3 months, would you or would you not be acceptable to say, well, in fact, you'll still be within the intermediate levels up until March, or did you accept that the complaints were started at about Christmas 2020, and even though they didn't have the stations in place, there probably was HS2 there in January, February, March?
The evidence certainly suggested that the problem had arisen in terms of in sense of complaints from the local community having identified an increase in that had arisen quite early in 2021. Yeah. But I mean, in a sense, your lordship's question is it brings us back to the real issue, which is it's one thing to say for the agency to say through me. Of course, we must respond to the strong recommendation of Public Health England, having taken the decision ourselves to be guided by them as to what the objective should be in terms of air quality. But it's quite another thing to say that if, for having taken what we consider in our judgment to be the effective measures which are best placed to get us there, we don't get there for reasons of scientific and environmental reality, if you like, then we are, so far as Matthew's concerned, we are guilty of a breach of his rights under Article 2 and Article 8. That's where things get difficult in my estimation. And that certainly is, at least as we see it, that's the consequence of the declaration. It's a sort of Damocles hanging over the agency, however hard it tries, if you will, reasonably.
So if there was one day in January or February when he went above one part in 1 billion, whatever it is, 2022, you would have breached his Article 2 rights under that declaration.
And if odour levels exceed the limit specified in the first of the 2 strong recommendations, then the same applies.
Yeah, the first recommendation about the half-hourly ones, that goes to Article 8, does it? And it's the second new recommendation that goes to Article 2. Is that fair, or have I
it's not specific. It's not, that division isn't specified in the identified in the judgment.
The hourly ones, the half-hourly ones, couldn't go to Article 2, could they?
It would be difficult to see.
Right.
Yeah.
And the long-term levels could go either to Article 2 or Article 8, I suppose.
Yes. I mean, the half-hourly one. It's fair to say that in his evidence and in the Public Health England reports, NC4, there is a recognition that exposure to excessive odour, H2S, can affect people's well-being.
Yeah, but does it affect people's life? That's the question.
No, that I would suggest would be a difficult proposition.
So the 24, the half-hour guideline, you say goes to Article 8, and the other one, the acceptable levels long-term, goes to Article 2 and or 8.
Yeah. in my submission, on that analysis, you can well understand why the judge wasn't prepared to accept that there was a present breach. Because on any view, the guidance from the agency and the report that he regarded as a beacon, just to use his words, shining through this case, the Public Health England advice and NC4. On any view, their position insofar as long-term health impacts was concerned was that the position at the moment was acceptable.
Well,
but
so far as Article 2 is concerned, you can say that. That is why there's no present breach of Article 2 at present, because you're still within the 364 days intermediate level. I'm not sure that you can say that, can you, for Article 8?
What you can say with Article 8, which we have never doubted, is that Article 8 was engaged in this case.
Doesn't mean anything, actually.
Well,
engagement is marriage, is family law. Question is breach, really. Is there an interference which has to be justified?
Yes.
That's the better way. So because you're above the WHO levels, there is an Article 8.1 interference, and therefore it's got to be justified.
And I probably didn't put it as clearly as that, but our position in this case has never been to doubt that we were in the business of having to justify an interference, and that for that purpose there was an operational duty, and that it was necessary to show, if challenged, that appropriate steps were being taken in order to fulfil.
But I can understand your argument that there can't be, on your case, a present breach of Article 2, given that you fall within these limits at the moment. But in relation to Article 8.1, if you actually focus on the issues, we don't know yet whether or not there is a present breach of Article 8.1 as at the date of the hearing or the judgment, because you accept there's an interference within Article 8.1, and the question is whether or not...
Well, interference and breach are different things.
That's why I've put it in terms of interference and justification, and I've avoided breach and I've abandoned engagement. Yes.
Well, I understand.
And you've told me that it is within, and I've written down it's within Article 8.1.
Yes.
So the question then is, was it justified?
Yes.
As at?
But that's the critical question, and that's because it's only if the justification that is advanced within the scope of Article 8.2 is found wanting by the court.
Yes.
That the court is in a position.
Article 1 and 8.2 combined, but the point is you're saying there couldn't be a present breach, but you've got to justify the fact that the levels, as far as Article 8 is concerned, the levels were going above the guidance levels in March to June, 36% at one station, 14% at another station.
Yeah.
And you've got to show that what you were doing as at the date of the hearing was sufficient justification for that interference.
Had the levels been below,
you'd have been okay.
Then I would have said that there would be no question.
Yes, but you can't say that, and you just did, though.
They weren't, but they were above, and therefore I used the language of triggered. That's actually the language of the European Court in the Fadieva case, which is the most relevant authority on this particular issue. But as we shall see when I take you to that case, which I'm going to do quite soon, because I do say it's really critical.
But triggered isn't very helpful. There are different conditions that must be met for Article 2, one of which is risk to life, and that you appear to accept was satisfied. And then you've got to consider whether or not the operational duty had been breached. And if all of those conditions are satisfied, there's a breach of Article 2. It doesn't really help to say we've satisfied one condition, therefore we will say it's triggered. It's like engagement. It's meaningless. The question is whether there's a breach.
Yes.
And for that, you need to consider all the relevant conditions for Article 8.2, risk to life and breach of the operational duty. And for Article 8, you have to show it's an interference within the meaning of Article 8.1, and it's not justified at the relevant date in 8.2. And if you focus on what the articles actually require you to prove, and you avoid triggering and engagement, it's much, much better. But that's really a personal.
I'm happy to, obviously, to phrase it that way. What I do hope, I better take you to Fadieva quite soon, I think, because it does. I do say that it provides the court with a route map, if you will, through. I use that phrase hesitantly, but a route map.
Right, you wanted to take us to 59, I think.
Yes, I did. This is at page 128. I mean, this paragraph is, and paragraph 60 need to be read carefully and together, because they are, my submission is that in the light of what the judge says he accepts, insofar as my step 2 is concerned, there was no justification for going any further. That's our submission. And we say that. I can pick up on the key points. Paragraph 59. Mr. Mole's step 2 is as follows. In the context of the public health concerns arising in this stage, including the concerns related to man himself, the EA took reasonable appropriate action of A, monitoring emission levels, and B, taking advice from PHE. Plainly, PHE is the appropriate state agency from whom to take advice. The EA's pleaded defence in this claim emphasises that the EA has worked and continues to work closely with PHE regarding potential impacts of landfill gases, and has done so specifically with respect to the quarry since early 2021. And that PHE has undertaken and published its risk assessment. And I've shown you the references in the detailed grounds of defence in relation to that. Then he refers to Dr. Coates's evidence, and picking it up about 12 lines up from the bottom of the page. There's a sentence just over halfway through the line, which begins, PHE has made clear and strong recommendations in the 4th PHE risk assessment. If the EA takes action which have as their purpose and design the implementation of PHE's recommendations and thus PHE's advice, that response will constitute a discharge of the positive obligations arising under Article 8 and Article 2 of applicable. That's because the Specialist Public Health Agency of the state has made strong and clear recommendations identifying what it is that needs to be achieved. It has done so by reference to what it has properly assessed to be appropriate health-based guidance values. Those guidance values and their applicability have been carefully chosen, clearly identified and explained by PHE, as can be seen in the 4th PHE risk assessment. PHE advice identifies the acceptable level of emissions. That includes the WHO half-hour guideline, 7 parts per billion, in which one strong recommendation applies. It includes the US EPA chronic lifetime level, to which the second strong recommendation applies. Once the use during 2021 of the US ATSDR intermediate value, 20 parts per billion, is understood, what PHE has clearly advised is that the US EPA reference concentration has been met from January 2022 as day 365 onwards. Now that's all my submission. As Mr. Mould submitted, the appropriate standard to evaluate risk is PHE's advice, and the appropriate way to assess progress is to establish monitoring, take PHE's advice and implement it. So if the EA designs an action plan involving the measures which it has designed as being sufficient in its judgment to achieve this outcome from this date onwards, then reasonable steps have been taken and the duty is discharged. I accept, says the judge, Mr. Mould, step 2. It's correct, an essential part of the analysis. I set out what it is that 4th PHE risk assessment is advising. I accept that the Environment Agency will discharge its legal obligations if and insofar as it takes action which, in its judgment, will be effective to implement that advice. It's not a question of this being sufficient, but also being necessary to discharge.
Mr. Mould, would it help if you just told us where you'd like us to read to, and we'll simply read it?
Indeed, I'm just conscious of the live streaming. But,
oh, I see. Yes,
yeah.
That's a fair observation. Yes.
To discharge.
No. Carry on as you were.
Yes. And then it refers to the pleaded defence, which I've already read to the court. And then I think I can go down to about...
But before you go further, the sentence beginning, I accept that the EA would discharge its legal obligations, that's fine. Is the judge correct to go further and say it's not only sufficient, but it's necessary, i.e. if you did something else, that wouldn't be compliant with Article 2 and 8? Wouldn't it depend, or could it depend on the circumstances?
It would depend on that. It would depend critically on the EA's judgment as the specialist environmental.
There might be new standards, there might be changes of climate, there might be all sorts of things.
Right.
So is necessary in that 5th line correct or not? It's not just a question of this being sufficient, but also this being necessary.
It's not, well, it's not necessary to say necessary. It would be sufficient to say sufficient, is I think the way of putting it. and that was my submission, that because I have in mind here, when I was making these submissions, that by definition, the agency's responsibility is focused on doing the things that it can do in the exercise of its powers and in fulfillment of its specialist judgment.
It's enough to say, well, that's what we're going to do, and if we do that, then we, the Environment Agency, have done what we're required to do by law.
Yes.
You are submitting, I think, to be absolutely clear that the judge's conception of it being necessary is wrong.
I'm saying it is in the sense of it being it going beyond what he needed to say and what he should have said. He should have it would have been consistency with the established principles under which the court defers. I hope that's not an unreasonable word to use. Defers to the agency's judgment as to what steps, what effective steps are available in order to realise the strong recommendations of Public Health England.
Because is the effect of adding necessary to mean that there is only one way
Yes.
That is the point.
Can discharge its obligations?
Yes.
And that wasn't your submission.
No, and it would be, and there was no evidence to support it.
Yeah.
But that's why he can go on and say, this is what is necessary when you get to paragraph 64. So I think it is important to look at the sufficient and necessary.
Yes, and I confess that the particular significance of that word is not one that we picked up in our written submission in that context, but it is in the light of the court's helpful intervention. It is indicative. Clearly indicative of where we say the judge has gone wrong, and it is indicative of the concern that if you like, the complaint that I stated at the outset of my submissions, which was that the judge has gone beyond what was justified in this case in granting the relief that he did.
Well, if the analysis or rationale, if you will, leads to the conclusion that the declaration needed to be issued, granted, if it rests on the conception of this being necessary, you say that that's wrong.
Yes.
And that, you would submit, presumably logically, is to undermine or goes to undermine the justification for the declaration. It's almost tantamount to saying the same thing.
Yes.
I mean, if his reasoning, of which that is a component part, leads inexorably from that proposition to the need to grant the declaration as he saw it, then you would say that falls at that hurdle.
Yes.
Is that right or not?
Yes, I think that is right.
Yeah.
Yes. And there's a better, in my submission, a more accurate exposition of what is needed, which is entirely consistent with the case that the agency was putting in evidence in the submissions I made, which is towards the bottom of the page, where you see there's a sentence that begins about halfway through a line, 10 lines up, what is needed.
Well, it's a bit above. He sets out the general bit from Fede Ava, which refers to the particular set of circumstances there.
Mm-hmm.
And there you'd had a steel mill built in the middle of a town, and they were supposed to clear a 3,000 metre safety zone, and they hadn't. And he turns, or you might want to say that he turns that into a general thing and says this is a clear encapsulation of what is sufficient but also necessary. I mean, if you had designed or applied effective measures which did take account of acceptable pollution levels, or you were in the process of doing so, that you would say would be enough. But what he's saying here is this is an absolute standard. firstly, you've got to have a standard, and the only standard is PHE, and then you've got to design to those standards.
Indeed, the passage he quotes is in my submission, highly revealing.
Yes.
Because he quotes, this is actually from the summary of the European Court's assessment of the whether of the Article 8.2 balance in Fadieva. So it goes directly to directly in point here. He quotes a passage in which the court said there's no information that the state designed or applied effective measures which would take into account the interests of the local population affected by the pollution and which would be capable of reducing the industrial pollution to acceptable levels. As we shall see, the thing that impressed the court in Fadieva was that the Russian state authority had simply not given the court any evidence as to what it had done or what it was going to do. It had made assertions about things having improved, but as the court said, the improvements, such as they are, have taken an awfully long time, and we still aren't there yet. So although you have a margin of appreciation in terms of drawing the proportionate balance between protecting the victims of this industrial pollution and other factors such as the economic well-being and so on, you haven't. We have no means of judging whether you're within or without the margin of appreciation because you haven't given us any information. So we naturally draw the adverse inference that you don't have any information.
So what the judge has done is to spell out from the statement in Fadieva about the information that was missing a duty to provide such information, and then said, and that's the only way that you can carry out your legal obligations in this case.
My lady, that is essentially it, yes.
Yeah.
And of course, the factual premise, no information, has no resonance in this case at all. There was plentiful information from the agency and from Public Health England in evidence before the court as to set out how the problem was judged to have arisen, the way in which the environmental permit regulated landfill gas generated by the landfill, consideration of the exercise of the regulatory powers within 2016 environmental permitting regulations, and whether they would or would not be effective in securing a solution to the problem. And then a clear indication from the specialist person within the agency as to how the tried and trusted techniques for dealing with this problem. And then an explanation from the case officer as to the measures that had been taken and would continue to be taken, including a review of their effectiveness, in order actually to bring the matter under control. One can't imagine, in my respectful submission, a clearer contrast between the position in Fadieva and the petition here.
So in a nutshell, you're saying what the judge has done wrong in principle is to take language which describes a particular breach on the facts and then turn that into a description of the duty's content.
Precisely.
In all cases, even ones where the facts are diametrically opposite.
Precisely. But the fact of elevated levels of gas is an important factor in raising the operational duty.
What? Sorry, if you've answered this, and just point me back to where the answer lies. What was as you understand it, the evidential foundation for the judge's view or judgment? In my judgment, he says it is necessary. What was the evidential foundation for that view or conclusion, as you understand it?
There was no of what is, in my judgment, clear encapsulation of what is sufficient, but also necessary.
But
it is
the evidence.
The evidence was essentially, as I understand it, NC4, because he saw NC4 as being an up-to-date and reliable exposition of a series of air quality guidelines, which, if met, would secure public health within the area surrounding the landfill site, and provided 2 recommendations as to what needed to be done in order to achieve an acceptable level of air quality to secure public health, both a long-term, a guideline as to long-term levels and a guideline in relation to short-term levels, which is more focused on those. That I hope is an answer. Which
Well, I think it is either an answer or close to being one. What was the expert evidence that founded that understanding of NC4, if any?
it was Dr. Kurtz's evidence.
Yeah. Can we just, I'm sorry if I'm being slow, let's just go
No,
back.
no, not at all. It's paid back to tab 22 in the supplementary bundle.
Yeah.
Paragraph, he gave evidence as to the health-based guidance values under that heading at paragraph 10 in page 393
Yeah.
through to paragraph 13. And then he explained certain consequences of the application of those guidelines to the circumstances of this case in paragraphs 14 onwards.
Seems to be a number of interrelated problems. One, he has treated those standards, the WHO one for the half-hourly ones and the EPA one, as absolute standards for all time.
Yes.
Now, you don't actually object to working to those standards because you haven't got any other standards at the moment, although you may or may not say you can't work to them for all time because they may change. They get more stricter or less stricter. But on top of that, he seems to be saying you've got to have some sort of design or plan which you can tie in specifically to those. And it's not enough to do what you've done, which is say we're reviewing it gently. We've got this plan, we'll have a look at the plan, we'll see what comes out of that and so on. And he's saying that's not enough. The content of the duty requires A, there to be standards for all times, and that is currently the PHE, and B, a design plan which is tied to those standards.
Yes.
That seems to be what he's saying.
Yes, that is our submission. The evidence.
I mean, that's effectively what he's saying in paragraph 63, where he rejects your step 3.
Yes, and the evidential basis for the, if you like, the reliability of those standards and their resonance as appropriate is a matter of fact for the agency to design to. That evidence, as I understand it, was that the evidential basis for that was Dr. Kurtz's evidence and the.
Well, he says you've gone to them for advice, and their advice is this, and he says there's a significant change between the third and the fourth, and he's saying, right, that's their beacon for all time, that's their clear standards, and you've tied yourself to that, and he says, therefore, that must be part of the content of the duty.
Yes, and that I understand it is the position. What he doesn't do, and this may be a feature, this may also assist my lord in relation to the question. What he doesn't do is to acknowledge this, to attribute any significance to the detailed evidence as to what the agency had already done and was continuing to do. It is a striking omission, in my submission, from these key paragraphs of his judgment, that he nowhere analyses the quality of the information that he had from the agency as to how it had approached resolution of the problem, and he nowhere acknowledges that the agency had made its own judgment as to what would and would not be effective. After all, let us suppose that the standards change 2 or 3 times over the course of a year. Let us suppose new standards come into play. Some further research is done, which gives a better understanding of levels which ought to be designed to, operated to in relation to preserving the health of children, for example. That won't. There's no reason why, in principle, why that should affect the Environment Agency's response as to what will and will not be effective in remediating excessive gas emissions from a landfill site through the control and management of gas. Now, it might, of course, it might in principle mean that there would need to be reconsideration of whether more extensive measures should be deployed in terms of enforcement, or possibly even bring into play the question of suspension or something of that kind. But given that here the agency's position was that at least the primary source of root of the problem was not the continuing importation of materials that were giving rise to the generation of hydrogen sulphide, but the fact that materials had come onto the site in breach of the permit, however that may have happened, which were already deposited and which were generating the gas. It was at least incumbent, in my respectful submission, on the judge to grapple with that and to say, because in the context of the Human Rights Act and of the alleged unlawfulness which he was faced with, which he was being asked to consider, the things that the agency had done and the reasons for them were absolutely central.
You seem to be saying a number of things, as far as I can see. You seem to be saying that you don't object to these standards at the moment because there aren't any other standards and you've gone out and got advice. But it's wrong, one, to elevate them into absolute standards for all times. Two, you just don't know whether they'll change. You just don't know whether it's going to be practical to meet it 100% of the time. There could be one day in February when you don't comply or the standards aren't met, and that would automatically be treated as a breach. And then thirdly, he's not taken account of what you've actually done. He's fixed an absolute standard, said you haven't got a plan that refers directly to BHE, therefore I'm going to make this declaration. It seems to be, I get the sense that you're merging those three things, or I might be wrong.
Well, no, those three things, those are 3 points, and the third of them is really goes to ground 1. And the second and the other 2 go to ground 2. So perhaps it was helpful not to make that clear. But it's the third of them that I'm particularly wanting to emphasise, which in relation to ground 1, which is that if the judge was going to find, as he put it in paragraph 63, I'm not satisfied on the evidence that officials in the EA have done what compliance with the applicable legal duties required. He needed to grapple with the things that they had done and were doing. Not least because that is what, as we've seen from the passage he quotes from Fadieva at paragraph 63, that is what the European Court have themselves focused on.
Is there a further point, which is that the judge acknowledges at the end of paragraph 63 that the fourth risk assessment was published on the 5th of August, and that your witness statements were on the 6th of August? You seem to be criticising your witness evidence for not engaging with the details of something that had only been published the day before all the witness statements were signed.
Yes, or perhaps at least, I mean, it may be that he wasn't criticising us, although that is certainly, I would respectfully accept, is a fair way of reading it. But saying that because of the timing, because the recommendation was, as you put it, really very new, you can't tell me that you have grappled with it, which in a sense is true.
Well, obviously.
But so what? I mean, in a sense, but I say that helps me, of course, because I say that the question for the judge was whether the whether that fact alone, if you will, justified the adverse inference that he effectively drew, that the agency wasn't grappling with the problem in the light of the advice of Public Health England. Hadn't had a chance to do so. Yeah. But as I've shown you earlier, it certainly didn't say that it wasn't prepared to do so, and its case through me was very clear in paragraph 59 that it intended to do so. I mean,
if you'd said, we don't care what they said in the fourth assessment, it's a new recommendation, we've done enough now, full stop, they'll have to live with it. That would be one case, but you're saying, no, this is different. He's put an absolute standard, the PHE advice. You haven't had time to respond to that yet because of circumstances, but you've said you're going to constantly keep matters under review, but you haven't got a specific document because it's only been a day, cross-referring to the PHE standards and saying, well, this will be met by Plan A, cap cell 1, or alternatively by new restrictions on gypsum coming on or whatever. Yeah. And you say, well, you couldn't have done that because you hadn't had the time.
No. I mean, I did. It's fair to say that as he records in paragraph 62, how shall I put it? I did the best I could to reassure him in the light of, and I invited him to infer that, if you will, that the agency's, that what the agency had said it was going to, had done and would do, should be aligned to. But I can see why.
The problem is you can't be sure about that. You hope that's why I was asking about review existing measures, or you have to adopt new ones. Yeah. You can't say yet that you've reviewed the existing measures to see if they will achieve the second recommendation. You couldn't have done that.
No, and
but you would say, but A, you weren't not going to do that, and B, if they weren't enough, you indicated that you were going to think about new measures insofar as you had power to do so.
Yes, yes.
Perhaps this goes back to the question I asked you a little earlier. I don't know. If you like, the juxtaposition of those two dates, the 5th and the 6th of August, new advice and evidence going into the court, says not one thing but two things. You might argue, I don't know. One is it hasn't been responded to, and the other is there hasn't been time to respond to it. The first is objectively true as a matter of fact. The second is also true as a matter of fact, but it's in the context of the, if you like, the track record to date, you might submit, that one has to look at that second, if you like, the ongoing consequences of the second factor.
I mean, my lord, that was essentially what I was seeking to I mean, there were two choices. Perhaps this is another, if you'll forgive me, this is another way of paraphrasing your lordship's point. In the absence of any actual stated position of the agency in response to the Public Health England most recent report, in order to judge where the agency might go, one was driven to drawing an inference. And the inference might be in the agency's favour that it would respond positively and react as it thought appropriate to that report, as my lord puts it, reviewing, possibly adding further measures, whatever it may be. Or the inference might be negative, adverse, that it would do nothing. It would simply continue on its own merry course, put that report to one side, and say, we know what we're doing, we don't need Public Health England to make difficult recommendations to us, we're going to carry on. Now, in Fadieva, the court was driven to the latter because it hadn't got any information. In this case, there was no, in my respectful submission, no reason for the court to do other than to draw the positive inference. Because the track record, as your lordship puts it, in the evidence, was that the agency was, put it colloquially, all over this case.
That's why the judge did what he did. He didn't draw the inference that you wouldn't respond. He didn't draw the inference that you would respond. He said, you haven't yet responded, and to get clarity, I will tell you what we've got to do. We've got to treat these standards as absolute, as early as possible for WHO, 1st of January for the EPA, and that's it. And that's what he did.
Well, we told him what we were going to do in paragraph 59.
Yeah.
And he didn't quarrel with that. So
It would be helpful to have the directions. We haven't got the directions as to when the evidence was due and so on, or at least I couldn't find them. It would be quite helpful to have that.
yeah, I don't.
The claim was the 5th of July, I think. And then there's a rolled-up hearing order with directions.
The hearing started on the 18th of
Yeah.
August, which was 12 days after the new guidance.
And the claims were only issued on the 15th of July, so it all happened very quickly, actually.
Yes, it did. And the judge charts the progress, what happened in paragraph 2 in his judgment, actually.
It would be quite helpful to have the directions, though, of the 23rd of July.
I'm sure we can make those. We'll get those. We'll have those brought in after the short adjournment.
Yeah.
What is? I've already made a submission in relation to the passage in Fadieva that the judge relied upon in paragraph 60. And it's fair to say that he saw Fadieva as having particular significance in this case because, as he put it, this was the one example of an in-the-moment case. But there is a striking factual contrast, and I appreciate it is a factual contrast, but nevertheless, in my submission, it's worthy of mention, between this case and the other European cases which deal with comparable or broadly comparable scenarios, that is to say, where the European Court has been asked to grapple with cases where hazardous or dangerous industrial activities have been in focus, and the question is whether the responsible state authorities whose task it is to regulate those activities have or have not fulfilled their operational duty in the context of Article 2 and Article 8 of the Convention. And those cases are the Turkish case, Ona Yildiz. The judge he analyses each of these cases in considerable detail in his judgment at paragraph 36 and following, and derives propositions from them in paragraph 42. Ona Yildiz, this was the case where the waste dump exploded, killing members of Mr. Ona Yildiz's family, and the claim was brought under Article 2, and the court found that there was a violation of Article 2 because the state authorities had not only had they taken no effective action to control or to manage the risk, but they'd positively encouraged the claimant to put himself into the risky situation because he and his family had set up home on a shanty town on top of the tip, and the authorities had done nothing had not taken any action to remove the shanty. In the case of Lopez Ostra, which was an Article 8 case, the claimant, Mrs. Lopez Ostra, and her family complained that their rights under Article 8 had been violated by virtue of the prolonged presence of an industrial facility generating excessive levels of hydrogen sulphide into the atmosphere over a long period of time, and that the state had been entirely passive in responding to that, notwithstanding that
they didn't even have a permit for it, which, as I
That's
understand
right.
it. And even after they got a permit, it's not easy from the judgment to see what went wrong afterwards. But even after they got the permit, they still didn't do much.
No. Well, the key point in Lopez Ostra was that, notwithstanding the very striking factual position, the state declined to accept that it had an operational duty. So the European Court said, understandably, of course you had an operational duty. So it's completely different to the present case. Fadieva is a case, as we've seen, where an industrial facility was operating for many years and generating a variety of a cocktail of noxious gases into the atmosphere above state legal emissions limits, and the state had established a cordon sanitaire around the factory with a view to protecting the local community from the effects, the health effects of this. But notwithstanding that, the cordon sanitaire hadn't been properly enforced. Mrs. Fadieva was living within the cordon sanitaire. She was on a waiting list to be rehoused, but she appeared to have been on the waiting list forever and ever, and there was no prospect of her being. And secondly, moreover, as we've seen from the passage quoted by the judge in paragraph 60, the state, when challenged, to show that it had taken measures to regulate this dangerous industrial process activity, had not provided any information. And then Budieva, which is a bit further removed, another Article 2 case. Budieva was a case in which there'd been a landslip, so this was an act of God rather than a man-made problem. But nevertheless, there'd been the court found there had been a failure to take necessary measures to protect Mrs. Budieva and her family from the risk of the landslip, which ultimately engulfed members of her family. And the court helpfully identified the principles. We set them out in our skeleton argument, which the court applies. What it shows is that the positive duty is essentially the same under Articles 2 and Articles 8, or very similar in its practical, and that when it comes to the question of whether effective measures have been taken, that is first and foremost for the state and the state agencies to judge. And there's a margin of appreciation at European level, which chimes, and the judge accepted this in paragraph 51 of his judgment, which is consistent with the established principles in this court, which defer to the technical and specialist role of a body like the Environment Agency or Public Health England. And my lords will remember the BACI case, which we put in the authorities, in which that proposition is identified. So, well, those are the that's a snapshot of the authorities. The judge has dealt with it in detail in that case. But when we come to ground one, which we've set out in our skeleton paragraph at page 13. Plainly developed the argument in paragraphs 35 through to 51, but we've sought to encapsulate the ground in paragraph 32. And if I may, for the reasons I said earlier, I'll just read that out. The judge erred in deciding that judicial intervention was either justified or appropriate in the circumstances of the present case. Holding the claim and granting relief, the judge failed to follow or lawfully to apply the clear and established principles stated by both the Strasbourg and domestic courts as to the respective roles of the appellant and the court. It was the appellant as the designated specialist statutory regulator, not for the court, to evaluate and determine the further action needed in order to restore gas emission levels at and in the locality of Walleys Quarry to acceptable levels and within an acceptable timescale in the light of the specialist guidance and recommendations given by PHE on the short-term and long-term emissions levels that should be achieved to safeguard health. This is the critical point. There was no evidence before the court that the appellant sought to avoid its responsibilities. Nor was there evidence before the court that the appellant had failed to assess and to take the practical measures that it judged to be necessary. The evidence was that the appellant had taken such practical measures, continued to take such practical measures, and would keep the need for further practical measures in addition to those already in progress under review and respond to the specialist guidance and recommendations given by PHE. This was not a case in which applying the established principles as to the fulfilment of the appellant's operational duty, any intervention by the court was justified or appropriate. So that is essentially the argument. I mean, it's developed and embellished in what follows, but that is what I have sought to. It's that argument that I have sought to develop during the course of my submissions thus far this morning. I should show you, I think, two of the European cases and also the Supreme Court's decision in Rabone. So if it's convenient, I'll just go to
but the argument itself, right or wrong, is a very simply stated argument.
It is. It is.
And you've just encapsulated it in that submission. And that's the argument, right or wrong.
Yeah, yeah. And the judge went too far in paragraphs 63 and 64. He went beyond what principle shows he should have done. Maybe go to firstly to Buddha Yeager.
Yes.
Which you have in the authorities at tab 15. They are numbered. It begins at page 389. Now, this was a decision of the European Court. As I have indicated, as I've said, this case on the facts is a little further away from the present case than some of the other authorities because it concerned a natural disaster. But as you see from the head note on page 389, the complaint was that essentially the state authorities knew about the risk and had not done it. That was sufficient to impose an operational duty upon them under Article 2, and that they had failed to discharge that duty in the circumstances of the case. I only seek to take the court to the general principles that are set out in pages 414 to 416 in this bundle, paragraphs 128 to 136 in the report. Uh, 128 explains that Article 2 includes both a negative and a positive obligation on states to take appropriate steps to safeguard the lives of those within their jurisdiction. 129, above all, a primary duty on the state to put in place a legislative administrative framework designed to prove effective deterrence against threats to the right to life. Pausing there, there's no issue that in the present case that primary duty has been fulfilled. The 2016 environmental permitting regulations provide a regulatory framework for the control of landfill operations, and they require, amongst other things, that a landfill site should be regulated via an environmental permit. And in this present case, there is a permit which was in operation, which you have as Exhibit SD3, tab, you'll note, tab 13 of the supplementary bundle. And we've drawn attention to the relevant provisions of the permit in our skeleton argument where we deal with the background. I wasn't going to take you specifically to those references in oral argument. Paragraph 130, this obligation applies, we see, to in the sphere of industrial risks or dangerous activities, and reference is made to the Honor Yildiz case. It has both a substantial and procedural aspect. positive obligation to take regulatory measures and to adequately inform the public about any life-threatening emergency and to ensure that any deaths are followed by judicial inquiry. The 132, as regards the substantive aspect, in the context of dangerous activities, special emphasis placed on regulations geared to the special features of the activity in question in relation to licensing, setting up, operation, provision, etc. That is the function of the permitting regulations in the present case. 133, the scope, this is a point I mentioned earlier, it's been recognised that in the context of dangerous activities, the scope of the positive obligations under Article 2 of the Convention largely overlap with those under Article 8. Consequently, the principles developed in the Court's case law relating to planning and environmental matters affecting private life and home may also be relied on for protection of the right to life. And 134, which is particularly in point in the present case, as to the choice of particular practical measures, the Court has consistently held that where the state is required to take positive measures, the choice of means is in principle a matter that falls within the contracting state's margin of appreciation. There are different avenues to ensure convention rights, and even if the state has failed to apply one particular measure provided by domestic law, it may still fulfil its positive duty by other means. In this respect, an impossible or disproportionate burden cannot be imposed on the authorities without consideration being given, in particular to the operational choices which they must make in terms of priorities and resources. This results from the wide margin of appreciation states enjoy, as the Court has previously held in difficult social and technical spheres. This consideration must be afforded even greater weight, and then it goes on to deal with the factual scenario of Budiyeva.
So para 134 enunciates a principle which possibly the judge didn't comply with.
My lady, that's our case.
Yeah.
Yes. And we say it translates into domestic law, at least in large part, in the approach that this Court has taken in Mott and in BACI to deferring to. I keep saying deferring. There must be a better way of putting it, because it's not an attractive way of expressing the Court's role. But in acknowledging the specialist, the technical and specialist role assigned to the agency.
You do cite the corresponding passage in BACI, I think.
We do. Paragraph 78, I think. No, 87. It's for the note. It's at tab 3, pages 64 and 65, paragraphs 87 and 88 in your Lordship's judgment.
And although no one likes to look at the facts, when you read the facts at 147 to 160 onwards, they're quite striking facts. They knew that there's a problem with mudslides. They were told repeatedly that last year's mudslide had damaged the landslide prevention barrier. They didn't do anything about it. They didn't put in any alternative policies to deal with it. And then at 153, they wouldn't put forward any explanation as to why they hadn't set up a warning post in case there was it. So, although I know you don't like looking at the facts, it's quite important to look at the facts.
No, I do like looking at them, but I recognise that one has to be careful, because obviously we're looking at transferable principles here. But no, my Lord, I would endorse the contrast between that case and the present one, which, as I said earlier, is a contrast that is actually...
It's not just for the purpose of contrast. When you read the general principles to work out how they apply, you've got to read them in this context. Yes. And when we come to our case, we have to read those principles, bearing in mind the context again. Yes. You can't just look at one fact and take it over, and you say that's what the judge did. He took one bit of Fadeyeva and he turned that into a general principle. But there's a general principle, which is at a very high level, read in the abstract. You can't do anything really. When you actually read through the facts and how it works out, that gives it real content.
Yes.
Anyway, that's what I was saying.
No,
interesting to read.
My Lord, yes, absolutely. And then, indeed, that your Lordship has I think, really put in, has paraphrased paragraph 136, which is the final statement of principle, in assessing whether the respondent state has complied with the positive obligation. The court must consider the particular circumstances of the case. Regard being had, amongst other things, to the domestic legality of the authority's acts or omissions. And we've already noted that in Labour's Austria, it was never a permit. In the present case, all the requisite legal and regulatory requirements have been are in place.
Here, it wasn't a question of them choosing to do A rather than B, and it was the wrong choice. In paragraph 151 and 155, they simply didn't do anything.
Yes. Yeah. The domestic decision-making process, including appropriate investigations and studies, complexity of the issue, especially where conflicting conventional interests are involved. That analysis of the position in the context of the positive obligation arising under Article 2, where the victims are at risk from potential or actually dangerous industrial activities, or in that case, known natural hazards, is reflected in the judgment of Lord Dyson in the Rabone case, which is where I go next. That's at tab 7. Now, Rabone was a case in which the complaint was a violation of the Article 2 rights of a psychiatric patient who was permitted to go on a home visit, and during that visit committed suicide. In that case, the hospital trust admitted negligence, but the issue was whether there was a violation of the positive obligation under Article 2. At paragraph 12 on page 128 in the bundle, internal page 83, Lord Dyson provided an outline of Article 2 in paragraphs 12 and 13. He identified the positive duty. At letter E, he identified its two distinct elements that we saw in Budieva: general duty to put in place a legislative and administrative framework, and he referred to it on a yildiz, and the second, the operational duty articulated by the court in the Osman case. He referred in just below letter F, this sentence: the court in Osman said that in well-defined circumstances the state should take appropriate steps to safeguard the lives of those within its jurisdiction, including a positive obligation to take preventative operational measures to protect an individual whose life is at risk from criminal acts of another. And at letter H, he referred to circumstances in which a breach of the positive obligation would arise, where the authority knew or ought to have known at the time of the existence of a real and immediate risk to the life of an identified individual or individuals from the criminal acts of a third party, and that they failed to take measures within the scope of their powers, which, judged reasonably, might have been expected to avoid that risk. That is the principle against which the question of breach needs to be considered. He returned to that at paragraph 43. This, page 137, he, having found that the operational duty was engaged in that case because the risk to life was immediate, he went on to consider the question of breach. There was a submission on behalf of the defendant that, notwithstanding the admission of negligence, there was a margin of discretion which was wider than the common law of negligence, which enabled the responsible doctor to avoid a finding of breach. And 43 judge said, I cannot accept the standard demanded for the performance of the operational duty is one of reasonableness. This brings consideration of the circumstances of the case, the ease or difficulty of taking precautions and resources available. And he went on to say that in those circumstances, of course, the margin of appreciation was misplaced. The trust failed to do all that could reasonably have been expected to prevent the real immediate risk of Melanie's suicide. And the Court of Appeal were right to say to hold. So again, the standard for assessment is one of reasonableness, which in my submission is a domestic encapsulation of the principles which are stated by the European Court in Boudier that I've drawn your attention to. Lady Hale considered the question of breach at paragraph 107 on page 154, 155. I'm not going to read that passage out, but her reasoning at letters B to D on page 155 acknowledge, in the context of the very, very different factual circumstances of that case, acknowledge the need to draw a balance between, depending on the circumstances of the given case. Those two cases are concerned with the positive obligations and the operational duty that arises under Article 2. And I draw those to your attention because although there was an issue below as to whether the risk to Matthew's life was sufficiently immediate to engage Article 2 in the present case, that issue was resolved in Matthew's favour by Mr Justice Fordham. There's no appeal against it.
You don't appeal against it. So you accept that the first requirement,
yes.
that there be a risk, a real and immediate, whatever the phrase is, that's satisfied?
Yes. And we had indicated in our written submissions below in an argument that if the court was against us on that threshold question, if you will, that we accepted that the positive obligation was engaged under Article 2 as well as Article 8, and we relied upon the passage that I've shown you in Boudier that says that in practice the discharge of that, the ingredients of that duty, of that obligation, and what is required in order to discharge the operational duty are essentially similar in the case of hazardous industrial activities, whether the analysis comes under Article 2 or Article 8. So when we turn to Article 8, Fadieva, which is at tab 16,
whether there was a breach of Article 2, whether or not you're taking reasonable steps in all the circumstances, was the same issue as whether or not it was justified under Article 8.2, because you've accepted there's an Article 8.1 interference.
Yes.
Right, again. Yeah. So when you're deciding breach for A2 and justification for A8, it's the same set of facts and principles,
yes.
you're saying?
Yes. I've already indicated the basic outline of the facts in Fadieva. The judgment of the court begins at page 446. And it runs from paragraph 64 through to 134, so far as the central question, which was their consideration of the alleged violation of Article 8 in that case. So far as they follow, as you would have expected, a logical sequence that reflects the ingredients of Article 8, paragraphs 1 and 2. The first step along that road was the alleged violation of Article 8, which is dealt with in paragraph 64 through to 88.
And you accept here, just so that I'm clear, that there was an actual interference which attained the level of severity to make it fall within 8.1, and therefore the justification onus was on you. You accept that?
Yes, I do.
Right.
And one can see again, one can see similarities in the factual matrix. For example, by looking at paragraphs 83 and 84 on page 449. This is in the court's assessment of the applicability of Article 8 in the present case, which begins at paragraph 79 on page 448, you see. And at 83 and 84, the focus of the court's assessment was upon, as regards whether Article 8 was applicable, was upon, amongst other things, the evidence of excessive levels of polluting gases in the atmosphere, the duration of that pollution, and the fact that that pollution was both short and long term in its incidence. And the significance of that, so far as the applicability of Article 8 is concerned, is manifest from paragraphs 87 and 88 on pages 450 and 451. Where the court says, in summary, the court observes that over a significant period of time, a matter of years actually, the concentration of various toxic elements in the air near the applicant's house seriously exceeded the relevant levels. The Russian legislation defined those levels as safe concentrations of toxic elements. Consequently, where the MPL is exceeded, the pollution becomes potentially harmful to the health and well-being of those exposed to it. This is a presumption which may not be true in a particular case. The same may be noted about the reports produced by the applicant. It is conceivable that despite the excessive pollution and its proven negative effects on the population as a whole, the applicant did not suffer any special and extraordinary damage. In the instant case, however, the very strong combination of indirect evidence and presumptions makes it possible to conclude that the applicant's health deteriorated as a result of her prolonged exposure to the industrial emissions from the Severstall steel plant. Even assuming that the pollution did not cause any quantifiable harm to her health, it inevitably made the applicant more vulnerable to various diseases. Moreover, there can be no doubt that it adversely affected the quality of her life at home. Therefore, the court accepts that the actual detriment to the applicant's health and well-being reached a level sufficient to bring it within the scope of Article 8 of the Convention. So it was the existence of those elevated levels of polluting gases in the atmosphere from the plant, which affected her private and family life, that justified the conclusion that the article was engaged.
There's an interference with the right to respect for life within the meaning of Article 8.1.
Yes, yes. Then, the second question was the attribution of that alleged interference to the state, which was dealt with in paragraphs 89 to 93. And that issue essentially was concerned with the fact that the polluting plant was not directly operated by the state, but was operated by another operator. But we can see that at 92 and 93, top of page 452, the fact that the authorities in the present case were in a position to evaluate the pollution hazards and to take adequate measures to prevent or reduce them was a factor, was sufficient to raise the issue, as it was put, of the state's positive obligation. Again, in the present case, as I've already submitted, there was no question. The agency raised no issue as to that point. They accepted that their regulatory powers placed them in the same position in the present case. So then, the decisive question, as your Lordship has put to me in 93, it remains to be determined whether the state is, in securing the applicant's rights, has struck a fair balance between the competing interests of the applicant and the community as a whole as required by paragraph 2 of the article in question. Then the court turned to that, and it set out certain general principles. And 96 is of particular relevance in my submission to the present case. However, where the state is required to take positive measures, the choice of means is in principle a matter which falls within the contracting state's margin of appreciation. There are different avenues to ensure respect for private life, and even if the state has failed to apply one particular measure provided by domestic law, it may still fulfil its positive duty by other means. Therefore, in those cases, the criterion according to the law of the justification test cannot be applied in the same way as in a case of direct interference by the state. 97 referred to the point that was raised earlier regarding the factual position in locus ostra, and that domestic legality is a factor in the overall judgment as to whether the Article 8.1 interference has been justified. Legitimate aim, 99 to 101, there's no issue in the present case that the operation of the landfill and its regulation in order to provide void space for the disposal of wastes is anything other than a legitimate aim. And so the decisive question in the present case, indeed as it was in that case, is the third component of the Article 8.2 analysis, which begins at paragraph 102, necessary in a democratic society. Paragraph 102 refers to the margin of appreciation, which is left to the national authorities. So familiar that I won't read that paragraph out. Paragraph 105 refers to the residual role of the court, if you will. It remains open to the court to conclude that there has been a manifest error of appreciation by the national authorities in striking a fair balance between competing interests of different private actors in the sphere. However, the complexity of the issues involved with regard to environmental protection renders the court's role primarily a subsidiary one. The court must first examine whether the decision-making process was fair, and as such to afford due respect to the interests safeguarded to the individual by Article 8, and only in exceptional circumstances may be go beyond this line and revise the material conclusions of the domestic authorities. Then it set out the arguments, and at 108, the applicant, 4 lines in, the applicant has made this argument. Secondly, it failed, that is to say, the government, to implement effective measures in order to prevent or minimise environmental pollution. In spite of compelling evidence of unacceptable levels of pollution from the Sebastopol plant in breach of the domestic limits, the government has merely asserted that no question arose of limitation, suspension, or discontinuation of its activity in connection with the environmental pollution. Then the government's arguments in response. The government, one can see the assertions at 113 to 115, page 456, basically an assertion that things have got better. Then the court's assessment begins at 116. There were 2 questions that the court found it necessary to consider in order to conclude its assessment in relation to the issue of necessary in a democratic society. The first was the alleged failure to resettle the applicant. That's not one that I'm going to focus on here because it's not a part of the current factual matrix. But what is clearly of relevance both legally and factually is the second of those considerations, which begins at page 458, the alleged failure to regulate private industry. And at 124, the court said, recourse to the measures sought by the applicant before the domestic courts, urgent resettlement or reimbursement of the resettlement costs, is not necessarily the only remedy to the situation complained of. The court points out that the choice of means calculated to secure compliance with Article 8 in the sphere of the relations of individuals between themselves is in principle a matter that falls within the contractive state's margin of appreciation. In that respect, in this connection, there are different ways of ensuring respect for private life, and the nature of the state's obligation will depend on the particular aspect of private life in issue. In the present case, the state had at its disposal a number of other tools capable of preventing or minimising pollution, and the court may examine whether in adopting measures of a general character, the state has complied with its positive duties under the Convention. Then in 125, there was the court noted the government's submissions about the improvement in the situation. At 127 noted that if there have been improvements, they've taken place over a slow period. But at 128 and 129, one sees the more detailed analysis that led to the conclusion that the judge quoted in paragraph 60 of his judgment that we looked at earlier. The court at 128 said, it might be argued, given the complexity and scale of the environmental problem around the Sebastopol steel plant, this problem cannot be resolved in a short period of time. Indeed, it's not the court's task to determine what exactly should have been done in the present situation, note, to reduce pollution in a more efficient way. However, it is certainly in the court's jurisdiction to assess whether the government approached the problem with due diligence and gave consideration to all the competing interests. In this respect, the court reiterates the onus is on the state to justify using detailed and rigorous data, a situation in which certain individuals bear a heavy burden on behalf of the rest of the community. Looking at the present case from this perspective, the court notes the following points. The government referred to a number of studies carried out in order to assess the environmental situation around the Cherevoporets steel plant. However, the government has failed to produce these documents or to explain how they influence policy in respect of the plant, particularly the conditions attached to the plant's operating permit. The court also notes that the government did not provide a copy of the plant's operating permit and did not specify how the interests of the population residing around the steel plant were taken into account when the conditions attached to the permit were established. The government submitted that during the period under consideration, Sebastopol PLP was subject to various checks and administrative penalties for different breaches of environmental law. However, the government did not specify which sanctions had been applied and the type of breaches concerned. Consequently, it's impossible to assess to what extent these sanctions could really induce Sevastopol to take the necessary measures for environmental protection. The court considers it is not possible to make a sensible analysis of the government's policy vis-à-vis Sevastopol because the government has failed to show clearly what this policy consisted of. In these circumstances, the court has to draw an adverse inference. In view of the materials before it, the court cannot conclude that in regulating the steel plant's industrial activities, the authorities gave due weight to the interests of the community living in close proximity to its premises. And then it summed up its conclusions. The first and the relevant summary in 133, which the judge quoted in paragraph 60 of his judgment, is the sentence beginning furthermore, about 6 lines in. Furthermore, although the polluting enterprise at issue operated in breach of domestic environmental standards, there is no information that the state designed or applied effective measures which would take into account the interests of the local population affected by the pollution and which would be capable of reducing the industrial pollution to acceptable levels. The capacity to achieve it was the way in which the court put it. So despite the wide margin of appreciation left to the respondent state, it's failed to strike a fair balance between the interests of the community and the applicant's effective enjoyment of her right in respect of her home and her private life. Accordingly, there's been a violation of Article 8. So apply those principles, particularly in relation to the alleged failure to regulate private industry. Essentially, the court was saying there, we don't have meaningful information and evidence from the Russian state authorities to enable us to be able to judge whether, as they assert, they have drawn the balance. In other words, whether they have actively made an assessment of the proportionality assessment of the impact on the victims as against the interests of the wider community and of the public. That being so, it hardly lies in the Russian state authorities' mouth to say that they should be able to pray and aid the margin of appreciation and we're willing to, and we are driven to the adverse inference that in fact that balance hasn't been struck. But that, in my submission, applying the same approach to the present case, the answer is compellingly different, and it is to the opposite effect.
Just pausing for a second. One might say, I don't know, one might conceivably say that Fadayeva is an extraordinary case in its facts. I mean, unrecognisable, one would think, in circumstances in this jurisdiction.
That may well be right.
I don't know whether that's right or not, but the question might be, however, what default against those principles did the judge find in the present case, if any?
It is, I say, and I say, you know, obviously with respect, it's not easy to see what default he found.
I think what he's done is when he says there is no information that the state designed or applied effective measures, that's the language in the declaration, and he's taken a situation where the breach was established, not least because they hadn't given information, to say the basic obligation is to design or apply effective measures. And if you haven't done it, that's it.
Yes.
That's what he's done, I think.
And that's and on that on that basis, I come back to my retort, which is, in order to justify that conclusion, he needed at least to grapple with the information that he did have from Miss Dennis and from Mr. Rowell as to the way in which the agency had gone, we say, conscientiously about the task of working out what the source of the problem was and what needed to be done in order effectively to address it.
The principal problem, you say, I think, is that he's taken a factual description, or part of a factual description, as to why the court was satisfied there was a breach there, and then treated that as the definition of what must be done in each and every case.
Yes. And yes, because the fundamental point of approach at the European level, the Strasbourg level, is you show us the information, you give us the material that enables us to see that you have recognized the problem, recognize you have a duty to take measures, take steps to resolve it, and the steps that you have taken. And in this case, your willingness to review them. And if you show us that, then we will ordinarily recognize that there's no reason for us to intervene, because the margin of appreciation has been properly applied, the fair balance has been struck, and the subsidiary role of the court, A, demands no interference, no finding of violation, and B, actually leans towards us stepping back.
But you say the judge has decided what you should do, and because you can't provide him with information about what he says you should do,
Because of
he's
the
found a
change.
breach. Well, he hasn't found a breach, he's given the declaration.
Yeah, yeah. So it is as we characterised it, I think, in our skeleton. It is, if anything, it's an advisory declaration.
Yeah.
He's saying, I think this is what you need to do. But it's not founded on any finding of unlawfulness, and nor could it be, applying the principles that I've just shown you in the relevant European and domestic authorities. So,
Is it worth just looking at what the judge said about Fadayeva? Or have we already done that in effect?
well, he analyses it in paragraph 39 on pages 111. doesn't, as I read that paragraph, highlight or identify specifically the particular omission of the Russian state authorities in Fadieva, which we've seen from culminates in the conclusion of paragraph 133. That is the failure to provide information.
Yes, he doesn't. Does he mention 133?
He doesn't, I think, mention it in this analysis. He does, of course, quote it, as we've seen already, in paragraph 60.
Yeah.
He...
Yes, he does.
He also refers to Fadieva in paragraph 50 under the heading, "This is not a looking back but an in the moment case," on page 121. And he does so at the bottom of the page as part of his analysis, which concludes the logic of the Strasbourg Court's decisions analysis in these cases would, in my judgment, involve the National Human Rights Court enforcing an HRA Section 6 type obligation, asking itself in the moment whether there is an identifiable content to the positive operational duty, and if so, gives such remedies as ensures that the duty is being complied with. And over the page he says, in Fadieva, for example, it could have been a domestic court judgment or declaration recording that the state authorities were under an obligation to take such steps as would reduce emissions to the identified acceptable levels. Caution is one thing, abdication is another. The inexorable logic of these human rights cases is that public authorities and courts must step up at the time. And he refers to that paragraph on page 64, where he identifies the outcome. In the final sentence, he says, in the penultimate sentences, he says, "What matters from this court is clarity as to what the EA's legal obligations are and what the EA must in law do." That puts the focus where it should be in this urgent, in the moment. See paragraph 50 above, human rights case involving a positive operational duty. But
well, I mean, I don't in any way want to trivialise your argument by mischaracterising it, but your submission essentially might be on this aspect of the case that this is not a failure of this is not the court stepping up so much as it is the court overstepping. Is that? I mean, I don't know if that's a trivialisation of the way you put it.
no, it's a fair encapsulation.
But is the judge right to deduce this inexorable logic from the Strasbourg cases, or
No.
has he read something into them that isn't there?
My submission is that he isn't right, because what he's effectively saying is that the facts that give rise to the operational duty, in the case of Fadieva, the excessive levels of polluting gases in the area, in law defines the content of the operational duty.
Well, I think the judge is quite concerned with two things. I mean, the first and basic thing is he comes back repeatedly to Fadieva to say there were statutory maximum permissible levels. He works out in Lopez what the actual facts were, and it seems to be critical to his idea that first there have got to be set standards. There aren't any at the moment in the United Kingdom, but you've tied yourself to the PHE guidance, and they do give guidance. So he said, right, that's the starting point. You've got to achieve those standards. And then he goes on to say, and because you haven't got a flight plan that shows you've done that, I'm going to give a declaration so that you know what you've got to do. You've got to achieve PHE guidance by the 1st of January for the second recommendation and as early as possible for the first. That's what he's done, I think.
Yes.
He's almost legislated for what you've got to do.
Yes. And I invite you to reflect, if I may, to reflect on this thought, this submission. It was the evidence that the actual levels of pollutants in the atmosphere exceeded the legal standards in Lopez Ostra and in Fadeyeva that supported the court's conclusion that Article 8 applied. It was the fact of those elevated levels of pollutions in the atmosphere that gave rise to the operational duty, and then which then in turn required the Article 8.2 justification to be considered. But the court, in neither of those cases, did the court say that the only way that the definition of that operational duty was in law by reference to those legal emissions standards or guidelines.
So you don't deduce from those, the reasoning in those cases, that there's an obligation on the domestic authorities to reduce the levels of atmospheric pollution in that way?
The third and critical component of the Article 8.2 justification, which is whether the interference is necessary in a democratic society, is no doubt informed by the presence of or the absence of legally specified emissions levels. But it goes far wider than that question. And critically, it goes to the question as to what the state has done and is doing and says it will do in order to vindicate the rights of the victim. Which then enables you to make an informed judgment about whether a fair balance has been struck between those rights and the competing interests such as the economic well-being of the country, in this case the need to maintain the operation of a waste disposal operation, which in itself is in the public interest and so on. So what the judge has done is he hasn't drawn his inquiry in paragraph 63 and 64 is drawn too narrowly. He's focused only on the recommended levels. He hasn't looked at critically what the agency had done in order to investigate and to take steps to vindicate the interests of the victim, Matthew Richards, and the community, through requiring measures to be taken in order to restore compliance with the permit, and in particular to, as advised and recommended by Public Health England in relation to health-based levels. Had he written paragraph 62(3)(a), in which he had surveyed the evidence of Miss Dennis, Mr. Brow, and Dr. Kirksey in detail, I suggest that he wouldn't have come to the conclusion that he did in paragraph 62 on a proper application of the principles in Fadeyeva.
What he says at 64, clarity is fine, you say, but what you can't do is say this is clear, this is a way of doing it, and then turn that into, and that is the way you must do it.
Yes, and in argument, I said, maybe this is in written submissions later, in consequential matter, I certainly recall making the point that it would, of course, be perfect. There could be no complaint about the court reaching a conclusion as to a factor that ought to weigh heavily in the mind of the regulator in the light of the material that he had in front of him. But that is a different consideration altogether.
But if you look at 64, it's just and convenient, provide clarity and reassurance, make it critical as to what outcome must be secured, practical and effective use of it. There's nothing there about whether or not it's connected with a breach of duty, because it's not saying that there's been a breach of duty previously or up to the date of the hearing. It's saying going forward, if you don't achieve this, there will be a problem, and it's in your interest to know what you should do.
My Lord, that's my ground too, effectively.
Yeah,
the judge is, but those sentences make it completely clear that the judge did not, in my respects, did not see himself as granting a remedy for a breach, either an actual or proposed breach of the Human Rights Act, of Section 7. In other words, he was not, he saw himself as granting an advisory declaration to give clarity.
I mean, he could do that, couldn't he? I mean, appreciate that's not specifically provided by Section 8, but you've still got the general law, and you can, in appropriate circumstances, grant advisory declarations, even if they're not asked for.
You can, but the question, in our submission, if one is to do so, one should, the circumstances of the case must plainly justify it.
Yeah.
And our submission is that this, not only did this case not justify it, but also that as a consequence of the terms of the declaration that he made, he has actually, he's created some...
He's not advised you what the law is, you say. He's advised you on what would be a jolly good idea.
Yes.
And if you do it, don't worry about the law.
But he strayed into the territory of Public Health England and of the agency.
If you move from this is a way to do it to this is the brackets only, close brackets way to do it, you enter the realm of judgment. I mean, that's to say expert judgment.
Yes.
In this field.
Yes.
Yes. Which you submit the court must not do.
Yes.
And maybe that lies close to the difficulty that you're seeking to persuade us exists in this case. That there was this step beyond the proposition that this was a way to do it to the proposition that this was the way to do it, and that involved an exercise of judgment which it was not for the court to make.
Yes. The judge disavowed any intention of so doing. But of course, on analysis, we say with respect to him, that is what he has done. Yeah. And he is elevated to legal certainty, matters of fact and expert judgment that are actually much better left to those who have the expertise and the scientific knowledge and so forth and experience to deal with it, which is the Strasbourg way.
Anyway, that's what you submit.
Yes, I note the time. I mean, that effectively is what I wanted to say in relation to ground one. I did want to come back and deal briefly with the second ground.
All right. Well, look, what I think we should do is stop now until 2:05. We'll hear you on the second ground then. And then after which we turn to Mr. Wise.
Yeah.
Yes, according to the division of work that you identified earlier on. Thank you very much. Then 2:05.